My name is Marty Hayes. I am the president of the Armed Citizens Legal Defense Network. The purpose of this video is to set the record straight about ACLDN. You see, you can hardly open up YouTube and not find comparisons comparing ACLDN to all these other companies out there providing self-defense insurance. The problem is for the most part, they get it wrong. Many of the details are incorrect. Sometimes they're simply out of date. And so I want to get the record straight to let you know from the president what the network consists of and how we operate. We started the network back in 2008, and that was after about 15 years of me teaching firearms full-time, being a part-time law enforcement officer, and also working on expert witness cases. I decided to enroll in law school to achieve something I always wanted to do, that get a Juris Doctorate degree and likely practice law. I went for 4 years and completed law school in 2007. But during law school, I shifted my focus from practicing law to forming an organization that could help armed citizens after using force in self-defense. When I started the program, I knew that I did not want to include insurance because that meant being regulated by insurance regulators, insurance commissioners, and having funding decisions made by insurance underwriters. I also sought the counsel of several of the industry luminaries, including Tom Givens, Dennis Tueller, Masad Ayub, John Farnham, and we started up an advisory board with the purpose of the advisory board being twofold. One was to give ACLDN credibility, and the other was to serve as advisors regarding policy decisions and to review cases if there are any questions regarding whether or not the incident was a legitimate act of self-defense. And to set the record straight, these people are not paid to be on the advisory board. Many of our competitors have paid spokesmen who make YouTube videos and appear in ads. We don't. At first, we had to put a limit on how much we could spend on any individual's case because we simply did not have the money in the legal defense fund. We started putting 20% of all member dues in the separate bank account, not to be used for network expenses, but reserved for members to use if necessary. We then realized that we could afford 25%, and that's where we're sitting at this time. And just to answer the question, the remaining 75% goes towards operating costs, which includes salaries, administrative overhead, rent, advertising, and even the cost of making YouTube videos. We also must pay income taxes out of that money, as our legal defense fund is taxable at current income tax rates. In 2008, we started with only a handful of members and no money in the legal defense fund. But now, after 15 years, we have grown the membership to over 21,000 members, and the legal defense fund is now over $4 million. Over the past 15 years, we have continuously upgraded our benefits to members. Before we get into that, though, I need to make a couple comments. First, because we are not an insurance company, nor purchase an insurance policy which underwrites the program like some other companies do, we refuse to use the term coverage. We don't cover anything. Instead, we have a list of benefits that members can't access if they qualify for them. What does that mean? That means there is no guarantee that we will supply financial assistance to any given member. Each individual request for benefits will be assessed as to the legitimacy of a viable claim of self-defense. Now, this may sound ominous, but understand a couple things. First, all the other companies also have this in their plans too. They just do not publicize it. The second is that our legal defense fund exists to help members, and we will do everything that we can to use that money for its intended purpose. We do not have an insurance underwriter who exists to find reasons to deny disbursement of legal defense funds. But we also know that we would be in big trouble if we assisted people to commit intentional criminal acts by saying we would provide their legal defense for an intentional criminal act. So how do we determine if the self-defense was legitimate? We use the standard that the courts use when giving jury instructions. If there is just a scintilla of credible, admissible evidence of self-defense, and the member was not the initial aggressor, in other words, he started the fight, and if the member was not committing a separate crime, like armed robbery, when an act occurred, we are very likely to decide to fund the defense. For example, to this date, we have had 30 requests for assistance, and we have turned down 3 or 4 of these because there was no evidence of self-defense. And we found out that there is no evidence of self-defense by talking to the member about the details of the incident. And after getting the story, he is asked, well, where is the act of self-defense? Typically, he says something like, hey, I had to try. Most of the time, though, there's at least the member's testimony that he was acting in self-defense, and that is enough for us to agree to fund the defense. We also turned down one member who was having marital problems and was separated from his wife. He dropped by her house unannounced and saw a strange car in the driveway. So he entered the house undetected and confronted his wife and her new boyfriend, and an altercation occurred, with him eventually pointing his gun at the new boyfriend. Well, that was an easy one to turn down, and a good example as to why we might turn down a case. If you are the initial aggressor, in other words, you started the incident, you will very likely lose your right to argue self-defense at trial. If you are committing an additional crime in addition to the alleged use of force in self-defense, we will deny the funding. You cannot go into a 7-Eleven and rob the store clerk, and when the clerk pulls a gun, you shoot in self-defense. You must be as pure as the driven snow. If you are a convicted felon, you cannot be part of the network, and if we find out that you are, we will deny assistance and remove you from the network. Now, having said that, we know people make mistakes, so if you are one of these people, go get your rights restored. At that point, we would welcome you into the network. If we find out that you have lied about the details of the case, we will also likely cease involvement in your case. Understand that in each case, we will make an individualized assessment, and hopefully there are circumstances which allow you to argue self-defense in court. So who makes these decisions? Usually the decisions are pretty easy, and after hearing the details, we can make a decision pretty quickly. But what if the details are confusing? If that's the case, we will usually run the incident by a couple of members of our advisory board. This doesn't happen very often, but the option is there. With insurance companies, these decisions will be made by the insurance underwriter, most likely someone not versed in self-defense law. The bottom line is that we exist to fund the defense of legitimate acts of self-defense, and we will not turn down a request if there is legitimate evidence of self-defense. And frankly, if that is not good enough for you, then we are likely not the right organization for you. Being attorneys and experts in lawful self-defense, we know how to effectively prepare a member for justifying your act if your case goes to trial. That rests with what I believe is our most important benefit, that being our educational package. You see, the defendant has an absolute right to testify in his behalf, and it is very likely you will need to do that to explain to the jury why you had a reasonable belief that use of force in self-defense was necessary. And the jury also has the right to hear what you knew about self-defense when you made that decision. For example, in my home state of Washington, there's a Supreme Court case expressly stating such. The case is State v. Janes, and the court wrote, "The long-standing rule in this jurisdiction is that evidence of self-defense must be assessed from the standpoint of the reasonably prudent person, knowing all the defendant knows and seeing all the defendant sees." With this in mind, we have put together a set of videos by our advisory board explaining many issues involved in self-defense. We also purchased from the publisher copies of Masad Ayub's book, Deadly Force, Understanding Your Right to Self-Defense. We supply that to our members too. Between the book and videos, you will receive many hours of top-notch education, much more than any of the other companies. Okay, thanks for sticking with us up to this point. I felt it necessary to give a little information about the network in order to put our list of benefits into perspective. You see, the network is really simply a big club consisting of people who are passionate about the right to keep and bear arms for self-defense. And we are tired of people being prosecuted after legitimately using force in self-defense. So let's get into the details about our program. Our cost is only $105 per year, $150 for the first year, which includes a setup fee in the educational package, and you can include your spouse for an additional $70 per year. We don't have monthly payments. If we offered a monthly payment option, we would have to add at least one staff person just to handle our program. And that would mean we would have to increase dues. We don't want to do that. One of the biggest benefits of our program is that you get the right to choose your own attorney. We will never assign an attorney for you. When we set this program up, it was one of the things I was adamant about. You see, I am selfish, and I wanted a program for myself, my wife, my instructors, and my students. It was never about a business opportunity. After spending 20 years in law enforcement and the legal arena, plus my law school education, I know that not all attorneys are created equal. When it is my freedom on the line, I want the absolute right to choose who represents me. You can even change attorneys if you're not happy with your first choice. We've done that before too. Also note, many people do not know how to select an attorney, so that is why we have our network-affiliated attorney program, which consists of over 400 attorneys nationwide who you could choose from. Also, and this is very important, at this stage you will not be alone. You see this phone? It is my own personal cell phone, and if you're involved in an incident, you can call me. In fact, I want you to call me, irregardless of the time of day, and we will then start working on your representation. I, or a representative of the network, will even fly out to your location and begin the process if necessary. Now, there's only one condition in selecting your attorney, that being their fees must be reasonable. They must be in line with the norm for the area. For example, in my area, attorney's fees usually average $200 to $250 an hour, but I would expect fees to be much higher in urban areas. If we choose to fund a defense, we will pick up the tab for all the costs: attorney's fees, experts' fees, investigators' fees, court costs, and any other fees necessary for the best possible defense. We're only limited by the amount in the Legal Defense Fund, which is currently at $4 million. At first, when we were poor, we said 1/2 the amount in the fund was a practical limit we could spend. But now we don't say that, because we know costs would very likely be under $500,000, and that would be for a full-blown, high-profile case. We will provide funding for any act of self-defense. Doesn't matter whether or not you're using a firearm. We will provide funding for brandishing, also known as unlawful displayer. In fact, we encourage people to not shoot immediately, but to perhaps warn the person at the gunpoint if you want them to stop doing what they were doing. We will also provide funding before you have to go to a grand jury if you're in a grand jury state. We also want you to be represented immediately after an incident, not just after you're charged with a crime. We'll provide funding for an attorney immediately so your legal rights are protected. Many companies disallow any hint of a domestic violence situation when assessing use of force incidents. We don't do that. We're going to look at the case and decide whether or not it was legitimate, regardless of previous relationships with the other individual. Additionally, you don't have to call the network immediately after an incident. We don't have any time restrictions. I know one company requires you to call them within 72 hours, or you simply are denied benefits. We don't have that. In fact, one case, We had a person call us a couple months later, and we picked up his legal defense. Okay, what about the use of alcohol? Many companies prohibit use of alcohol when you're carrying a gun. And while it's not necessarily a good idea, we also know that people have a drink once in a while, beer or wine with dinner. And so if leaving the restaurant, you end up using your gun in self-defense, we're not going to deny you the right to have a good legal defense. Many companies also require recoupment, meaning that if you are found guilty or plead guilty to a lesser crime, you end up having to pay back the legal costs for your defense. You see, it's illegal to insure criminal acts. So if you end up being convicted or even plead to a lesser offense, you may have to pay back the insurance company for the costs of your defense. Be sure to read the fine print of your contract and ask questions before you sign up for any one of these insurance-backed companies. How about appeals? Most of the self-defense insurance companies will not cover appeals because by doing so, they would be insuring a criminal act. But since we're not insurance, we will fund an appeal, assuming that there was a valid reason for an appeal. What are valid reasons for appeals? Errors in rulings from the judge, prosecutorial misconduct, jury misconduct, ineffective assistance of counsel. There are many more possible reasons for a valid appeal, and if we funded the case to begin with, it's because we felt you had a valid claim of self-defense, so we would also likely fund the appeal. Since we're not an insurance company, we will not provide liability insurance for your acts with a firearm. But what we would do is fund the legal defense against a lawsuit. You see, insurance invites lawsuits. If a plaintiff's attorney knows that there's $1 million insurance, then he would likely file a lawsuit, even if it's unwarranted. He knows that the insurance company would rather settle than go to court. Let's talk about bail for a moment. How bail works is the judge sets a monetary amount that he or she hopes will guarantee you come to trial. You can either post that amount yourself, or if you don't have the money, then you can hire a bail bondsman. They usually charge 10% of the total bail, and likely on a large amount, they would require collateral for them to underwrite the bail. If it's a huge amount, say a $500,000 bail, then you're likely going to have to put up the title to your house, the title to your mom and dad's house, your gun collection, all of your Krugerrands, anything else that would add up to the $500,000 in order for him to be comfortable that you're going to go to court. Have you ever heard this from one of the other insurance companies? They don't explain it, but you need to understand that getting bail isn't necessarily automatic. We'll pay the 10% for you, but if you don't have the other collateral to put up, then you may not get out of jail. What we do not provide benefits for are red flag laws, psychological counseling, lost wages, cleanup, or firearms replacement. We also don't provide funding for accidental or negligent discharges. The bottom line, we will provide funding for legal costs for any legitimate act of self-defense, and will include funding for experts, investigators, and other costs. Funding will be determined on the merits of the case, and we can deny benefits if we choose to. If we didn't explain this, we could be accused of being insurance, and we would not function for the benefit of our members if we were controlled by insurance commissioners or other regulatory agencies. You get to choose your own attorney, and if you don't have one, we can recommend one for you, or we will even come to your location and help you choose an attorney. Remember, I started this organization for me, my wife, and our friends, and I would have it no other way. Assistance starts immediately after an incident, not after you've been charged with the crime. Thank you for sticking with us. If you still have questions, give us a call or consult our website. You can find us pretty easily. Thank you.